medical marijuana, how states and employers cope with medical marijuana use. And it is being presented by Monica Talaferro, who we are pleased to have with us again. She presented the same topic for our ADA conference, and it was a pretty popular topic. It's a hot topic right now, and so we asked her to come back and present it again. So thank you so much, and I now hand it over to Monica.
Thank you, Carlene, and thank you, Maynard. I am extremely excited to present this topic again. As Carlene said, this is very popular, and we often have a lot of conversation around this topic. So again, this training will be on medical marijuana and the ADA. And of course, whenever you have a training on marijuana, you must have a pun in your title. So today's pun is hashing out how states and employers cope with medical marijuana use. And on the right-hand side of the slide is just a bushel, I guess, of marijuana plants. Slide 9, please. So the next slide is just our disclaimer, because I am an attorney, so you know we attorneys love disclaimers. And this is just to let you know that this information is for informational purposes only. So before you act on any of the information in this presentation, please be sure to consult your attorney or your medical professional, because I am not a medical professional. So you can determine whether or not this information fits your needs. And this training is a representation of my views, not the views of my employer. And the last part just says all liability with respect to actions taken on this content are hereby disclaimed, which basically means don't sue me. Slide 10. So we're going to go over several topics today. The first will be key terms, and this is just so we have a general understanding of what we're talking about when we're using these terms. Then I do want to spend a little bit of time going over the history of cannabis in the United States and also the history of the ADA and primarily the illegal drug provision in the ADA. This is a more advanced training, so I won't get into the basics of the ADA. We'll just jump right into the illegal drug provision. And then lastly, we'll talk about medicinal cannabis in the workplace, which is what you're all here for. What does the ADA say and what do the state laws say? Slide 11. So by the end of this training, hopefully you will be able to explain the history behind the illegal drug provision. We're going to spend a little bit of time talking about that. You should be able to interpret this provision to both support the argument that marijuana is an illegal drug under the ADA and to read it to support that marijuana is not an illegal drug under the ADA. And of course, we'll go over which is the right answer, but I do want you to be able to understand both ways of reading the provision. Slide 12. Objectives 4 through 7. We're going to discuss some court cases that have talked about medical marijuana, because I know that's helpful for a lot of you to be able to make some decisions. And then we'll talk about some reasonable accommodations that you can provide for applicants or employers who use medical marijuana. We're going to describe examples of states that protect medical marijuana in the workplace. And hopefully you can be able to differentiate between when a reasonable accommodation is required for medical cannabis. Slide 13. This is our first section, terms to know, and on the right hand slide it's a human head with some cogs in it, which should symbolize our brains working together. So let's go to slide 14, and let's get into the first term, which is marijuana, which I will also refer to as cannabis. So according to the CDC, marijuana is also known as weed, pot, dope, cannabis, but it's the actual dried flowers and leaves of the cannabis plant. Marijuana contains a couple of different compounds, but we want to focus on THC, which is the psychoactive component, the component that gets you high. And then there's cannabidiols, which is also referred to as CBD, and that's what I will refer to it as. CBD is not mind altering. Now, you probably have noticed that you see CBD a lot more, depending on where you live, in grocery stores, Whole Foods, gas stations, on billboards. CBD is becoming very popular, and that's because in 2018, the current administration made it legal to grow hemp. So the CBD that you're seeing in these stores where marijuana is not legal in your state, that's coming from hemp, not marijuana. So that CBD will not get you high. It does not have that psychoactive component, and it comes from hemp, which has a lot less THC than marijuana. So let's go on to slide 15. And let's talk about how marijuana can be used to treat certain ailments. Now, I'll read some of these from the screen, but I do want to point out that just because you don't see it on the screen doesn't mean that marijuana can't be used to treat it. Because marijuana is an illegal drug under federal law, there is not a lot of research done on how marijuana can treat certain ailments. So an employee could very well be using medical marijuana for a bona fide reason, and it just could be that they have worked out with the doctor whether or not this will work for them. So a few of the ones on the screen are Alzheimer's, appetite loss, cancer, Crohn's disease, eating disorders, epilepsy, glaucoma, mental health conditions like schizophrenia and PTSD, multiple sclerosis, muscle spasms, nausea, pain, a wasting syndrome, and inflammation. So these are just a few of the ways that marijuana can be used to treat ailments. On slide 16, this slide is talking about the medical benefits of CBD, which we discussed a little bit earlier, and THC. And in the middle, there's a marijuana plant leaf. But CBD can be used to treat anxiety, depression, inflammation, inflammatory bowel disease, migraines, nausea, pain, psychosis or mental disorders, and seizures. And THC, which is the component that gets you high, that can be used to treat anxiety, glaucoma, insomnia, low appetite, muscle spasticity, nausea, and pain. And again, I just want to reiterate that there is limited research, so there could be very many other ailments that marijuana can be used to treat. So on the next slide, slide 17, on the left-hand side, there is some gummy candy. Some are gummy worms and some are gummies in other unknown shapes. But this slide is how is medical cannabis used? How do you ingest it? So most of you are familiar with smoking, that marijuana can be smoked or vaporized, but it can also be mixed with food, and we call this edibles. So this could be Rice Krispie treats, brownies, butter, cake. You can mix it in a variety of foods. It can be brewed as tea, used as an oil, as a tincture. You can take it in peel form, and it can also be in lotion. And like I said earlier, you can see a lot of CBD lotions and salves and things in the store now, but cannabis can be used in that way as well. So on slide 18, we do want to talk about the health risks associated with marijuana. We don't want to just talk about the good stuff. So 1 in 10 can become addicted. And if you're under the age of 18, then that can increase to 1 in 6. Heavy users of marijuana can have short-term problems with attention, memory, and learning. Smoking, of course, can damage lung tissue, and those who use it frequently in high doses, that can lead to disorientation, anxiety, and paranoia. And of course, temporary psychosis, such as hallucinations or paranoia, can also come from heavy use of marijuana. On slide 19, before we get into the cannabis history, Carlene, I don't know if there are any questions, but just feel free to stop me if I'm rambling on. So on this slide, we're just going to talk about the cannabis history. And I'll try to go through this quickly, and I know some of you will be asking why we're talking about this, so I'll wrap that up nicely during the end of this section. So let's go on to slide 20, and let's talk about before the 1900s, because after the 1900s is when we started to see the change. So cannabis was grown in the United States by the settlers, primarily for hemp, but it was widely used for medicinal purposes. On the next slide, slide 21, things started to change around the Mexican Revolution of 1910.
I'm sorry, Monica, this is Boehner. One of the questions that we've gotten so far says, it is my understanding that those who provide this product don't like the term medical marijuana, but prefer medical cannabis.
Exactly, and we'll get to that. And I'm so glad that you brought that point up because that's what this whole section is about. So thank you. We'll definitely talk about that. Okay, so the Mexican Revolution of 1910. This is when we really start to see this change from referring to cannabis as cannabis to marijuana. And this came from, because there was this Mexican Revolution going on in Mexico, Mexicans began to legally immigrate into the United States. And so cannabis smoking became a little bit more popular because Mexicans brought that habit with them. So marijuana then starts to have this negative association because people say that the word marijuana was used to associate it with Mexicans to give cannabis this foreign sounding name. So it was called marijuana. And this is when states began to regulate the drug in order to control immigrants. So if we go to the next slide, slide 22, we can talk about the stigma. And so we know in 1911 that California State Board of Pharmacy was quoted as saying, "They are a very undesirable lot, and the habit is growing in California very fast. And the fear is now that it is not being confined to the Hindus alone, but they are initiating our whites into this habit." And then by 1925, we start to see all of these news clippings like the one on the screen from the New York Times that says, "Mexican, crazed by marijuana, runs amok with a butcher knife." So we start to see that marijuana is being associated with immigrant population, not just from Mexico, but from other places. And it's being associated with violent behavior, running amok with a butcher knife. And there's some other quotes about how it led to satanic jazz music and things of that nature, but we'll get to that. So on slide 23, 1930 is really when things started to, at the federal level, change as it relates to regulation. So on the screen is the picture of Harry Ansler, which is a bald, old white man in front of a stack of books, which I assume is his office, and he's in a suit. And beside him is a quote that he said, and the quote is, "Marijuana is the most violence-causing drug in the history of mankind." So Harry Anslinger was appointed the first director of the Federal Bureau of Narcotics. Now, a lot of people, when you read articles, will say Harry didn't have a problem with marijuana before he became the director of the Federal Bureau of Narcotics. But once he became the director, this marijuana crusade became more of job security for him. He needed to do this so that he could maintain his job and justify being hired. So on slide 24, Ansler's hearing testimony. So there are all these hearings going on about what do we do about this medical what do we do about marijuana? And again, this is the term that they were using at the time. And so Harry gets this letter from a journalist that he reads on the floor during the hearings. And one of the quotes from the letter is, "I wish I could show you what a small marijuana cigarette can do to one of our degenerate Spanish-speaking residents. That's why our problem is so great. The greatest percentage of our population is composed of Spanish-speaking persons, most of who are low mentally because of social and racial conditions." And you'll notice that marijuana here is spelled with an H as opposed to the J that we spell it with today. But a lot of the regulations were written spelling marijuana with an H. But this is just an example of the type of propaganda that was used to give marijuana, as opposed to using the term cannabis, this negative connotation to make people fear it and to make people see it as this evil drug. So if we go on to slide 25, Some of you may be familiar with the movie Reefer Madness, and you can Google it and watch a few clips of it on YouTube. But this is on this screen is a movie poster from the movie Reefer Madness. And the whole point of the movie was to convey how evil marijuana is. So this movie poster, at the top, you see the word marijuana, and it's kind of written in creepy letters. And then there's a banner that says weed with roots in hell. And then there's another one that says not recommended for children. Excuse me. And then there's a creepy hand over some marijuana cigarettes, and each has a word. One says lust, crime, sorrow, hate, shame, despair. And then there's at the bottom of the poster, this writing that says weird orgies, wild parties. And then on the side, it says misery. And then there's this image of this white woman in her house robe who looks either maybe sad or high, I don't know. But the point is to convey that marijuana is this creepy, evil thing that causes people to have wild parties and orgies and commit crimes. So slide 26, this is when we get into the regulations. And so the first federal regulation, because remember we said that states were regulating to control the immigrant populations, the first federal regulation occurred in 1937. And this law was just taxing marijuana. That's how they tried to control it, is just by putting a tax on it. And this went on for decades until 1969, when the Supreme Court said, hey, you can't do that. That's unconstitutional. And so Congress came together and they said, okay, here's what we're going to do. And they came up with the Controlled Substance Act, which most of us are familiar with today. And when they developed that act, they listed marijuana as a Schedule I drug, which means that they determined it had no medical use and it had a high potential for abuse. Now, I mentioned in 2018, just to add to this list, that the current administration decided to make hemp, which is a little bit different from cannabis, cannabis marijuana, in that it doesn't get you high, but they made it legal to grow hemp. So that's the most recent one in 2018. But let's stick with this 1970 time frame, and let's move on to slide 27. So this is a quote on this slide from John Ehrlichman, who was the senior advisor to Nixon. And some of you may be familiar with this, but he was quoted as saying, and he's referring to this time frame when Nixon was in office, that we knew we couldn't make it illegal to be either against the war or Black. But by getting the public to associate the hippies with marijuana and Blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. So let's move on to slide 28. And this is just to summarize this whole section and the question that was asked by the previous attendee. Because of this history of using the term marijuana and this idea that it was created, I'm sorry, to associate this behavior with immigrants and to give it this negative connotation, there are a lot of people in the cannabis community who prefer to use the term cannabis as opposed to marijuana. So I always think it's important to have this discussion when talking about medical marijuana, because it's important for us to think about how our views of marijuana came about. Where do we get them from? Why do we think the things we think? And the reality is that if you believe that marijuana is this evil-causing drug, it's going to be very difficult for you to sympathize with an employee who is taking it for a bona fide illness. So this is why I like to take the time to discuss this history. I'm just going to check the question box now. And I think we're okay. So I'm going to move on to slide 29. And this is just where we are today. So today, there are about 33, maybe 34 states, including the District of Columbia, that have legalized medical marijuana. And of course, there are 14 states that have legalized recreational marijuana. All of the mid-Atlantic states, which is DC, Maryland, Delaware, Pennsylvania, West Virginia, Virginia is the last one, but they have all legalized medical marijuana. Georgia has legalized marijuana in the sense of you can use cannabis oil only. So I just want to throw that exception out there. But for all of the other states that have legalized medical marijuana, you can consume it in whatever variety is available in your state. Generally, in order for a person to get medical marijuana, they have to go before a medical professional, get some sort of doctor's recommendation or doctor's note, because we don't call it a prescription, but some sort of note from their doctor saying that they need this medical marijuana to treat a specific ailment. And generally in all of the states, it's a state regulated activity. So the state controls how the person accesses it, where they can access it. So let's move on to what the ADA says about cannabis in the workplace. That's slide 30. Okay, I'm just checking the question box. So slide 31, ADA and the drug use history. So as I mentioned before, when the ADA was first drafted, it did not have an legal drug use provision. And of course, we know from the ADA that the ADA protects individuals with a disability, qualified individuals with a disability. When the ADA was drafted, they didn't take any consideration about the use of illegal drugs. But what happened was when the Rehabilitation Act was drafted, drug users were receiving benefits by claiming that their drug use was a disability. So Congress said, hey, remember when we wrote that Rehabilitation Act and we had all those people who were using drugs claiming protection under that act? Let's not make that mistake again. So when they started drafting the ADA, they said, we got to make sure that the ADA does not protect people who are using illegal drugs. We don't want that to happen. And so when we go to slide 32, the ADA illegal drug exemption was added. And this provision says, for the purpose of this chapter, the term individual with a disability does not include an individual who is currently engaging in the illegal use of drugs when the covered entity acts on the basis of their use. So we see right off the bat that the ADA is saying we're not protecting people who use illegal drugs. But what is an illegal drug? So let's move on to slide 33. So the ADA defines an illegal use of drugs as any drug that's basically unlawful under the Controlled Substance Act. But they go on to say, such term does not include the use of a drug taken under the supervision by a licensed healthcare professional or other uses authorized by the Controlled Substance Act or other provisions of federal law. So of course, when medical marijuana was legalized, employees and employers both thought that this definition supported their argument. So if we move on to slide 34, we can see the employee's interpretation. So the employee would say, well, clearly I'm protected because you said that the term does not include a drug that's taken under supervision by a licensed healthcare professional. Marijuana is taken under the supervision of a licensed healthcare professional. So clearly I'm protected. And then of course, if we go to the next slide, slide 35, we can see the employer interpretation, and the employer would say, no, if you read the provision carefully, it says that if the drug is unlawful under the Controlled Substance Act, you can't use it. So even though it says it has to be, you can use it if it's under the licensed healthcare professional, it still goes on to say, or other uses authorized by the Controlled Substance Act, meaning any use has to be authorized by the Controlled Substance Act, so you, employee, are not protected. So of course, this case made it to the court, And it's very interesting because it started out in California, and it actually wasn't an employee case at all. What happened was 2 cities in California decided to shut down their dispensaries and said, hey, you can't do that here. And so the people who were using those dispensaries came together and said, no, you are discriminating against us because we have a disability. Under the ADA, we should have access to this medical marijuana dispensary. And so this case went to court, and the plaintiff sued under the ADA. So I'll just give you a moment to think about who won, and I think most of us probably know how this turned out. But of course, the city won because the court said, no, the ADA clearly says that in order for, if an illegal drug is one that is unlawful under the Controlled Substance Act, there's not 2 exceptions, meaning that whatever use has to be authorized under the Controlled Substance Act. And so the court said medical marijuana is illegal under the Controlled Substance Act. Therefore, it is an illegal drug under the ADA, and the ADA does not protect you. So even though this wasn't an employment case, this still holds true for the employment sector. So if we move on to slide 36, in big bold letters, we see that the ADA does not protect marijuana users. So a person who is using medical marijuana cannot claim protection by the ADA. Now, there are a few exceptions. So if we move on to slide 37, there are a few cannabis products that are approved under federal law. One of them is a cannabis-derived product called Epidiolex, and this was approved by the FDA to treat seizures. It is not a Schedule I drug like the rest of cannabis products. It is a Schedule V drug, so it is legal in all states. So an employee can legally take Epidiolex and without violating federal law. In the next slide, slide 38, there are 3 synthetic cannabis approved products under federal law, and they are Marinol, Syndrose, Sesamet. And each of these are not listed as a Schedule I drug. They're all used to treat nausea associated with chemotherapy. Now, because these have THC, it is possible that they will show up on a drug test. So it's just important to keep that in mind as an employer, that there are some cannabis products that are legal. And you can go to their websites for each of these drugs, and they have a lot more information. Okay, so let's move on to slide 39. There's also one other exception that I want to address, and this case was an EEOC case. It's EEOC v. Pines v. Clarkston, if you want to look it up. But in this case, an employee was terminated from her position because she used cannabis. So she went to her employer and she said, yes, I failed the drug test because I used marijuana to treat my epilepsy. And so the employer went on to question her and say, you have epilepsy? Well, I don't think that a person with epilepsy can handle the stress of this job. Are you sure that your epilepsy is not going to be a hindrance in this employment sector? So they started asking all of these questions about her disability. And those of you who are in this employment labor sector know that that's generally a no-no, right? And so when this employee went to court, she said, hey, they fired me because I have a disability. And the employer says, no, we didn't fire you because you have a disability. We fired you because you failed the drug test. You tested positive for marijuana and you can't do that. And the court said, well, I'm not really sure if you fired her because she tested positive or if you fired her because she has epilepsy, because you asked a lot of questions about her disability and her ability to do the job. So this is an important lesson for all of us because it reminds us that even if your state has said that you can fire a person who uses medical marijuana, you better be very careful about how you handle that situation. Because if the court determines that you really fired them because of their disability, then you're going to be in trouble. And so again, just to summarize, in this case, that the employer was questioned about her disability and the employer expressed concerns about her being able to do her job because of her disability. and that got them in trouble. So if we go to the next slide, slide 40, we see that this case was settled and the employer got $42,000, which is pretty minimum. Maybe it was a year of her salary, I don't know. And the court just said, you can't do that. We can't tell if you fired her for marijuana use or if you fired her because she had a disability. And so they decided to settle out of court in this case. So now that we've talked about how the ADA handles medical marijuana, let's move on and get into what you're all here for, which is cannabis and the states. Slide 41. And I'll just pause here because I do see some questions in the box. Carlene, I don't know if you can help me out to see where we are with the questions.
Sure. Can you hear me okay?
Yes.
Great. Okay. So, yes, I was just going to ask if we could pause for a second. So, one of the first questions we have is, do standard drug tests differentiate between somebody who might be, using medical marijuana or THC or CBD levels, so someone who's just using CBD products? Is there a difference between those?
Okay, I see the questions. I'm going to repeat it because it was a little fuzzy coming in. But the question is, do standard drug tests differentiate between THC and CBD levels in the sample? So we'll talk about drug testing a little bit later, but just to briefly answer your questions, drug tests, when they're testing for marijuana, they're looking for THC. They're not looking for a CBD. They're looking for THC because marijuana is going to have THC, whereas hemp, for example, THC in hemp is not going to show up on a test because it's like 0.3%, which is a very minimum, not going to get you high. So drug tests for marijuana are looking for the THC. I see there's another one that says in Pennsylvania, I'm not sure you can smoke medical marijuana. I believe Pennsylvania you can, and actually we'll talk more about Pennsylvania in this next section because there are some cases there. FYA, DEA descheduled Epidiolex in April, so it is no longer a controlled substance. Thank you, didn't know that. So that we can keep that in mind. And again, Epidiolex is one of the ones that has a really good website about their drug, so check that out. There's a question that says the other cannabis drugs can be used for pain too. I think you're referring to maybe the ones that were legal on a sheet. And again, if you go to each one of those, they'll tell you what the drug can be used for. And because they're approved by the FDA, they're very specific about what that drug can be used for. But as far as I know, it's generally chemotherapy for the ones that have been approved as something other than a Schedule I drug. Someone said, how do we address the fact that you can test positive for THC long after days and even weeks after the high has passed? Very good question, and we will talk about that. So thank you all for your questions. Let's move on to slide 42, and let's talk about how the states handle it, which is really going to be helpful for most of you since we know that people are not going to be protected under federal law. So states take very different approaches, and I'm sorry, I will not be able to address all the states. I will highlight some, but it's very important for even the states that I highlight that you go and you look up those laws. One, because they change fairly often. There's a lot going on in this medical cannabis sector. And two, because they're and we'll kind of discuss this, they're very different levels of protection. So some states have anti-discrimination laws that say you cannot discriminate against a person, but it doesn't say what you do when they test positive. There's some states that have laws that explicitly say that you're not required to accommodate. And when we're talking about accommodation, it's a little bit different than how we normally think of it in the ADA sector, because some courts talk about accommodating the use outside of the workplace, and some talk about accommodating in the workplace. So this is very different ways of looking at accommodation. There are some states that have laws that explicitly require an accommodation. Actually, there's only one, but we'll talk about that. And then there's some states that don't say anything. They're just like, I don't know, figure it out. We'll figure it out when you sue somebody. So let's go on to slide 43, and let's talk about states that have a law on the books that require an accommodation. And again, because there are some states that where the court may have said it or something of that matter, but there's only, let's go to slide 44. There's only one state so far that has a law that clarifies the accommodation process, and that state is Nevada. And you'll see throughout this training that Nevada is really leading the way towards providing employment protections for people who use medicinal cannabis. So again, Nevada is the only state that explicitly requires an accommodation by law. And their law reads a little something like this. Employer must attempt to make reasonable accommodations for the medical needs of an employee who engages in the medical use of cannabis if the employee holds a valid registry identification card, provided that such reasonable accommodation would not, 1, pose a threat of harm or danger to persons or property, 2, impose an undue hardship on the employer, or 3, prohibit the employee from fulfilling any and all of his or her job responsibilities. So we see from this law that Nevada is using some of that ADA language that we know about undue hardship. Some of us are very familiar with that. So they're kind of using some of that ADA language to extend those protections via their state law. And so in Nevada, you can kind of view it in the sense that you would view any other ADA issue, because their state law is kind of mirroring what we are familiar with in the ADA. And again, Nevada is leading the way in this area. They are, I believe, the only state that has a law as succinct as this one is. And if you're looking at creating a policy and you want to be as generous as Nevada, you should look to them to think about what your policy should look like. So let's go on to slide 45. And we'll talk about states that protect medicinal use. I'm going to check the question box. There's a question that says, what does the law state when it comes to providing reasonable accommodation to use medical marijuana and public services? So I won't talk about public services in this training because this training is specific to labor and employment, but you can kind of, when I read the statutes for different states, and again, each state is different, I'll try and point out which of those states would extend those protections to public services. And you can tell by the way that the law is written. So let's move on to slide 46. And we're still on states that protect medicinal use. And those states that protect medicinal use do so by having an anti-discrimination law. And I'll just read this list of states for those of you who can't see the screen, but they are Arizona, Arkansas, Connecticut, Delaware, DC with an asterisk, and we'll talk about that asterisk, Illinois, Maine, Minnesota, New York, Nevada, Oklahoma, Pennsylvania, Rhode Island, and West Virginia. So each of these states have some sort of law that protects employees in some sort of way. And they're all written differently, and they all give different levels of protection. So again, I won't be able to discuss all of them, but I will highlight a few, starting first with District of Columbia on slide 47. So the District of Columbia is very interesting because they don't really say anything about the private sector other than having this law that says that an employer may refuse to hire an employee who tests positive for marijuana. But when it comes to public employees, people who work for District of Columbia government, they go into a lot more detail and they provide a lot more protection. The District of Columbia is also a good way to model your own policy. And what they do is basically they split employees up into these safety groups. So let's say if you're a police officer, a firefighter, or if you drive any sort of vehicle, then you have a different drug testing requirement as someone who does not do those things. And they have 3 different groups. There's like safety sensitive, protection sensitive, I can't think of the third name. But the only people who are required to have a pre-employment test for marijuana are those people who we are most concerned about being under the influence. So like I said, firefighters, policemen, those people who, and drivers, those people who do those type of jobs, they're required to have a pre-employment marijuana test, whereas other employees are not subjected to that marijuana test at pre-employment stage. They would only be faced with the marijuana test if they appear to be under the influence, which we refer to as reasonable suspicion testing, or if there's post-accident testing. So if you get in an accident, generally you're required to go submit to a drug test. So there are a few other states that take this approach, but this is one way to kind of avoid dealing with the hurdles of getting into whether or not somebody is using medical marijuana, especially if you're in a state where recreational marijuana is legal. So again, if the employee tests positive for marijuana and they're safety sensitive, then they're not disqualified from employment. And they're also allowed to take a second drug test. And I believe Nevada does this as well. We'll talk about that when we get to drug testing.
We did get a couple of additional questions. Let's see, the one that you got up to. Woo, we're getting questions coming in here. Let me back up a little bit here. Okay. Let's see. So here's a good one. How do we address the fact that you can test positive for THC long after, days and weeks after the high has passed?
Yeah, so good question. And I'll tell you when we get to the end about, I have a whole slide on drug testing. So we'll talk about some tips maybe of how you can handle drug testing. But it's very true. And that's one of the biggest problems with marijuana testing is that an employee could have used, depending on how much they use, they could have used weeks ago and then test positive. So, I mean, marijuana tests don't tell you whether or not a person is currently under the influence, which is very different from alcohol, for example. We know when you take a breathalyzer, we have a number and we can tell from that number whether or not you're under the influence. There's nothing like that for marijuana, and that's one of the problems with testing for marijuana.
Yeah, that is difficult. So what is the law state when it comes to providing reasonable accommodation to use medical marijuana and when it comes to public services? So we'll talk about reasonable accommodation a little bit coming up on the presentation. Great.
Yes.
Then there was one about Nevada, because you brought that up. What might happen in Nevada for a school district or university that needed to comply with the Drug-Free Schools and Communities Act?
Okay, you went out a little bit, but I think maybe you were asking about maybe federal laws that have requirements, and again, we'll talk about that as well, but you're not required to violate a federal law, but I'll talk about some federal laws that people assume that actually don't. So we'll get into those laws as well. Okay.
And this one might be a good one for a little bit later, because it's what is the point of an employee obtaining a medical cannabis card if they're not protected? So I imagine that's also one that you'll be addressing moving forward.
Yep, great point. I mean, you are exactly on the right thought process, and we'll talk about that. So let's move on to Rhode Island on slide 48. So Rhode Island has this law, and this is exactly what the question is just talking about, where it says a qualifying patient card holder who has in his or her possession a registered identification card shall not be denied any right or privilege for the medical use of marijuana. And so for the person that was asking about other protections outside of the employment sector, if a law is written like this and it says any right or privilege, that means any right or privilege, so not just employment. And a lot of these laws are not specific to employment, so that could include other areas as well. So what happened in Rhode Island is that there was an intern who was applying for an internship at a fabric company. She used a cannabis to treat her migraines because she couldn't take any other prescription pain pills because she was allergic to them. So of course she could not pass the drug test. So the fabric company said, I'm sorry, we sympathize with your situation, but we cannot hire you because you use medical marijuana, and the federal law says that we can't hire you. So this intern, she filed suit. And so the court said, I'm sorry, let's go to slide 49 so you can see the court's reasoning. And the court said, well, the employer's policy only prohibited drug use at work. This employee was not using the drug at work. She was using it outside of work. And the court goes on to say that the law, what we just read, requires the employer to accommodate her marijuana use outside of the workplace, meaning that you have to allow her to use it outside of work. And that's the accommodation that they're referring to, which is different from the accommodation that we think of in the employment sector. The court goes on to say your burden is very minimal. So we kind of hear that undue burden language, because you don't have to change your policy, because your policy didn't just say you don't have to use it at work. You can't use drugs at work, I'm sorry. And this employee was not using the drug at work. And then the court goes on to say she's not asking for you to do like change her shifts or do any other type of modifications. So all she's asking is for you to allow her to use this drug outside of work, and you as an employer should accommodate that. And then the court goes on to say, yes, we understand that this drug is illegal under federal law, but federal law does not say that you can't hire her. It just says that the employee can't use the drug. That has nothing to do with the employer. So in this case, we see the Rhode Island Court saying that you can't use the Controlled Substance Act to say that it prohibits you from hiring an employee, because that's not what the Controlled Substance Act says. The Controlled Substance Act just says that marijuana is an illegal drug under federal law. It doesn't say anything about what employers have to do. So the court did not buy this excuse from the employer that because the Controlled Substance Act banned it, they couldn't hire her. Now, the important thing about Rhode Island's law is that Massachusetts and Pennsylvania, they all have very similar laws. And while the court in Pennsylvania has not said a whole lot, we know that because those laws are the same, then the ruling is probably going to look the same, meaning that you're not going to be permitted to fire an employee because they use medical marijuana outside of the workplace. So let's move on and talk about Connecticut. There are a few of these I want to get through. So Connecticut also has this law about protecting medical marijuana card holders. And in this case, an employee was taking a cannabis pill to treat her PTSD. And of course, she failed her drug test. And so the employer says, hey, like, there's this drug-free workplace act. And because of that, we can't hire her. And the employee is arguing, if you look at this law, it says that no employer may refuse to hire a person or may discharge, penalize, or threaten an employee solely on the basis of such person's use of the drug. And so the employer tried to say, well, I mean, we didn't fire her because she was a card holder. We fired her because she used the drug. And the court says, well, what's the point in being a card holder if you can't use the drug? That doesn't make any sense. And I really love this case because the judge in this case started his opinion with a lyric from a song. And I'll give you an opportunity to guess while I talk about it. But if you remember the theme song from Wonder Years, or if you watch the show on Amazon Grand Tour, they use the song there. But it's a very popular song. And the lyric is, I get high with a little help from my friends. I love when judges add humor. But of course, this song was done by the Beatles. And then, of course, it was remade for the Wonder Years version. If you're my age, that's the version that you're familiar with. But the judge says, what's the point in saying you can have a card if the person can't use the drug? So you can't use that as an excuse. And so let's go on to slide 51. And let's look at the court reasoning where they just said, like I said, the Drug-Free Workplace Act does not require you to even test employees. And the Drug-Free Workplace Act does not prevent you from hiring a person. So let's go on to slide 52 and let's talk a little bit about the Drug-Free Workplace Act, because a lot of employers have used this act to say, well, we can't have someone who does medical marijuana because of the Drug-Free Workplace Act, but they don't know what the act says. So if you're using the Drug-Free Workplace Act to rely on, let's talk about what it says. And of course, this is just a small snippet, so please go read it for yourself. But the act just basically says that you have to publish this statement telling your employers that they can't use drugs, manufacture drugs, sell drugs, any of that in the workplace. And you have to have this drug-free awareness program to tell your employees about the dangers of drugs, and that you need to have a policy on maintaining a drug-free workplace act. And of course, there are penalties for violating this act. But the court, at least in Connecticut, says nothing in this act says that an employer can't hire someone who uses medical marijuana. This only says that the employer needs to tell their employees that you can't do drugs at work. And none of these medical marijuana patients are asking to use marijuana at work. So let's move on to Delaware. Delaware, and if you notice, I'm trying to address the mid-Atlantic states. So that's where we are now, Delaware. So Delaware also has this law that says an employer may not discriminate against a person in hiring, termination, or any term or condition of employment, or otherwise penalize a person because of their status as a card holder, or if they test positive for marijuana on a drug test. So we see here that Delaware is one of the states that have gone as far as to say, not only can you not discriminate against them for being a card holder, but you can't discriminate against them if they test positive on a drug test. And so this goes to the question that someone asked earlier about what's the point in being a card holder if you can't use the drug. And we see that some of the states are agreeing with the sentiment. There's no point in allowing or giving protections to a card holder if they can't actually use the drug. So let's go on to Pennsylvania, because we had a question about Pennsylvania on slide 54. So Pennsylvania also has a law, remember, like we said with Rhode Island, that says no employer may discharge, threaten, or refuse to hire, discriminate in any sort of way a person who is using medical marijuana. But the interesting thing about Pennsylvania is that they do go on to say nothing in this act shall require employer to make any accommodation of the use of medical marijuana on the property or premises of any place of employment. So the key here is that Pennsylvania is saying you don't have to give an accommodation in the workplace, which is different from saying you don't have to accommodate the use outside of the workplace. They're just being very clear about, in Pennsylvania, you're not required to provide an accommodation for an employee to use it in the workplace. And most states are on this same idea that you don't have to allow someone to use drugs in the workplace. And then it goes on to say that the employee can still discipline an employee if they show up to work under the influence. And again, this is the case for all of the states. If someone shows up to work under the influence, that is a violation, or should be a violation, of your policy. And so you do not have to allow someone to be in the workplace under the influence. No state is requiring that. So let's move on to slide 55. And we'll talk about West Virginia. I'll do it briefly here because I'm sorry, Carlene? No? Okay.
Oh, I'm sorry.
So,
are we running short on time? You think you gotta?
We're here till 12:30, right? I mean, I'm sorry, not 12:30.
Yeah. Yes. We are here till 12:30. So I just wanted to mention, I think there was a recent case in Pennsylvania, I think end of September, something like that, that basically ruled that employees had private right to sue, I think, if they weren't hired or, because of, testing positive on a marijuana test. Am I right on that one?
That's exactly right. And a lot of these other states have ruled the same thing, that you do have a right to file suit. And so that's something for employers to be aware of. You really want to make sure that you're keeping up with these laws. And just like Carlene said, that just came out recently. Like I said, this area is rapidly changing. So it's not something that you can put on the shelf and 2 years later think it's going to be the same. Things are changing rapidly, and you really need to stay abreast of the laws in your state. Even set an alert if you need to, because these things are changing very rapidly. Okay, So let's skip over to slide
Thank you.
56. Thank you, Carlene. And I just want to summarize what West Virginia's law is, because that is one of the mid-Atlantic states. But basically, West Virginia's law prohibits termination based on medical cannabis use. And it requires, this is really important, employers to publish a written drug testing policy. And this is, not all states require this, so it's important to pay attention to this. But in West Virginia, you must have a written drug testing policy. And of course, they also say that you're not required to accommodate cannabis use at work, but they also go as far to limit the types of work that an employee can perform while under the influence, but they specify what they mean by under the influence, which a lot of states don't do. So this is important to take a look at that if you're in West Virginia. And then I just want to talk about Maryland real quick on slide 57, because Maryland is very interesting. So they have this law, right, that says that you can't subject the person to arrest or prosecution, and you cannot deny them any right or privilege for the medical use or possession of cannabis. But then when you go to Maryland's Cannabis Commission site, which is where you have to go if you want to get your cannabis card, that gives you all of the information. When you go to their site, they're very clear to let employees know that your employer can terminate you if you test positive for marijuana. Now, I haven't seen any court cases on this yet, but I think it's interesting to point out, because on one hand, it looks like they're protecting employees, but at the same time, they're saying, but if you test positive at work, then, I mean, that's on you. Whatever your employer decides to do, that's on you. So this is just one of the ways that you see when states first start getting into this business, they aren't quite sure of how they should handle these type of things. And Maryland is an example of that, because it appears that they're providing protections by saying you can't deny them any right or privilege. But at the same time, it's not in their law. It's just a line on their website that says that the employer can fire you if you test positive. So it's important to pay attention to little things like that. So let's move on to slide 58, and let's talk about states that have a law that says you're not required to accommodate. And of course, you're going to want to view those laws, because they could be talking about different things based on the state. So on slide 59, I'll just run through some of them. I won't read all of them, but they're there for you. But West Virginia, for example, is one of the states that we talked about. They have a law that says you're not required to accommodate in the workplace. Pennsylvania, another state we talked about, same thing, you're not required to accommodate in the workplace. And so you'll notice that a lot of these states are states that have anti-discrimination laws, but they've also just taken that step to say, we have this anti-discrimination law, but we're not requiring an employer to protect the use of the drug in the workplace. And just because a state isn't listed here doesn't mean that they don't agree. It just means that they haven't put a law on the books. We can skip to, let's move to slide 60, which we already talked about, but this is just so you can see West Virginia's law, which we just mentioned, that says that you're not required to accommodate in the workplace. And that's bullet 2, which says, nothing in this act shall require an employer to make any accommodation of the use of medical cannabis on the property or premises of any place of employment. So that's generally what those laws look like. So let's move on, and we're getting close to the end, so we'll have time to take a lot of questions, but let's talk about some of these best practices on slide 61. Let's talk about some best practices that I advise moving forward. And this will include a discussion on drug testing. And this will give you guys plenty of time to ask all the questions that you want to ask. So on slide 62, here's an analysis that I kind of suggest that you do. You want to first determine whether medical cannabis is legal under your state law, because we know that it's not legal in every state. If medical cannabis is illegal, then you know that you're not going to be required to provide an accommodation, because your state has said that that employee cannot have that drug. If medical cannabis is legal under your state law, then you're going to want to look to see what your state says about terminating somebody who uses medical marijuana. And of course, like I said before, those are generally going to be written as anti-discrimination statutes that say that you can't discharge, refuse to hire, threaten, retaliate someone who uses medical marijuana. We know from the previous discussion that some of those say based off them holding a medical marijuana card, and some of them say based off of the medical marijuana use. So it's important to make sure you know what your state is saying. Once you determine that, you want to look and see, is there a law that requires you to accommodate medicinal use of the drug? And we talked about Nevada, for example, and how they're leading the way in that area. The other bullet that's not on this slide that you want to think about is what your state says about an employee who tests positive for medical cannabis. What are you to do when that happens? We know, for example, that Maryland kind of leads us to believe that there's some protection, but then they add this sentence on their website, not in the law, a sentence on their website that says the employer can still fire a person who tests positive. So these are kind of all the things you want to look at when you're determining what your policy should be for your business. So let's talk about reasonable accommodations on slide 63. There are some accommodations that you can provide for employees other than saying our accommodation is that you can use it out of the workplace. Some of the things that you can do is you can, of course, modify your drug testing policy. And we talked about how District of Columbia, for example, separates employees into groups based off of the risk that their job poses. So maybe it's not necessary for you to test all of your employees, and you use a business necessity. Is it a business necessity that you test this particular person as opposed to this particular person? Of course, if you have someone who's driving, those are going to be controlled by federal laws, because there's some federal laws from Department of Transportation that may require you to drug test. Of course, if you have someone that's driving a forklift, then maybe you want to test that person to know what type of drugs they're using. But if there's someone else whose job doesn't pose that level of risk, maybe they don't need a pre-employment testing. Maybe you only test them if there's a reasonable suspicion or if there's some sort of accident in the workplace, and that's your policy to test after an accident. We talked about permitting off-site drug use, which is the second bullet, but another thing you could be if an employee needs to take cannabis at the same time every day, then maybe you want to make sure that their shifts are always at the same time. So you don't have to be concerned about them coming to work under the influence. And if you think of this in the same way that you think of any other drug, like any other painkiller that would make an employee dizzy or woozy, if you view marijuana in that light, that may help you think intelligently about the type of accommodations you can provide. So maybe if an employee needs to use it at night, you don't put them on a night shift. You put them on a different shift when they know that they're no longer under the influence. And of course, you always want to require that an employee shows up to work not under the influence. So those are just a few of the accommodations, and I'm interested to hear about any other type of accommodations that you may have provided in your workplace. But I'll just move on to the disadvantages real quick, and then we can take all of the questions at the end. So on slide 64, I do want to talk about some disadvantages of accommodation. And this is just a quote that I found in an article from the LA Times. I'm not quite sure. The study was published by the National Institute on Drug Abuse, but I'm not quite sure about how the study was conducted. But the quote just says that employees who tested positive for marijuana had 55% more industrial accidents, 85% more injuries, and 75% greater absenteeism compared to those who tested negative. Now, I will say that I believe that this study included recreational use, and we can argue that someone who is using cannabis recreationally has a different intent, purpose, and thought process as opposed to someone who is using it for a medicinal purpose. So maybe it's not fair to combine those two groups and make a comparison between them, because they really have different goals when they're using those drugs. So slide 65, understanding drug testing. We had a lot of questions about this. So urine tests generally don't measure the amount of THC. And when I say the amount, the test generally has a point, I'll say. So it's generally like 50 nanograms or something like that. And if you reach that point, then the test is positive. That doesn't really tell us whether or not that person is high or under the influence. That just tells us that they have that level of THC in their system. And again, as mentioned earlier, it doesn't tell us when they last used, which we know is a little bit different from alcohol. It also, it doesn't tell us whether the person is under the influence, and it doesn't tell us when they last used. So that's the problem with drug testing and why it may not be the most helpful thing for you to do in the pre-employment sector, because all it's telling you is that this person has used the drug. It could have been weeks ago, days ago, or hours ago. We don't know. So on slide 66, some of the best practices that I think that you should look into is developing a written cannabis policy and providing notice to your employees and to your applicants as well. And so they can understand what's expected of them. I say treat cannabis like alcohol, and what I mean when I say that is we're not concerned about whether or not somebody got drunk over the weekend. We're only concerned about whether or not they showed up to work drunk. So that's what I mean when I say treat cannabis like alcohol. Be more concerned about the person's impairment and not necessarily their use, because we don't get into what people did outside of work when they're drinking. We only care about when they show up to work. We talked a lot about Nevada, and I said that Nevada is really leading the way in this sector. And one of the things that Nevada and New York both have done is said you cannot test an employee for marijuana at the pre-employment stage. So that's, they're, like I said, really leading the way in that area. And that may be where a lot of other states are going to move towards, is just avoiding it, especially in those states where recreational marijuana is legal. It just creates a big headache when you're trying to decide what to do with these employees who are testing positive, but who are not under the influence. So both Nevada and New York, if you want to go look up those states, they are really saying, let's just stop this pre-employment testing for marijuana. It's useless if we're going to allow people to consume the drug illegally. In Nevada, they go as far as to say that you can't refire or refuse to hire someone who has a positive marijuana test unless there is another business reason or a federal law. There are exceptions for, like, again, firefighters and things of that nature. They do have exceptions, so you want to read those exceptions. And of course, if there's like a collective bargaining agreement that controls, those are all the type of sections. But for the general population, you cannot fire a person for testing positive for marijuana. And in some of them, in some sectors, they allow you to have the person take a second test. The employee would have to pay for it, but they get 30 days to take a second test. And the thought behind that is if they could refrain from smoking for 30 days, then they would be able to pass the test. But of course, if you're a medicinal marijuana user, that would require you to not take your drug for your disability for 30 days in order to test positive. So you want to read up on those areas to see which would fit your case. And of course, if there's some other sort of federal law, or if you have a federal grant that requires you to do something different, then you want to make sure that you're adhering to those. I think it's a good idea to provide accommodations for medicinal cannabis users in the same way that you would for someone who is taking a legal prescription. So we talked about how you could maybe adjust shift times if you needed to, or making sure a person has a consistent shift. They show up to work the same time every day, so they could have a regimen if that's what's required for them. Of course, you always want to have a policy that says that cannabis use is not permitted at work. And that's in the same way that you would prohibit someone from taking a painkiller that would make them impaired at work. So it's really the same. And of course, you always want your policy to prohibit people from showing up to work under the influence. No state is going to require you to do that. So I will take questions now. Carlene, if you are able to help me out here and let me know which ones I missed, I'll go through the chat box.
Sure thing. I think, let's see, if we could start back, did you want to address the couple that came through, for example, the one you were talking about, what's the point of a medical cannabis card?
Yes.
That sort of question. Do you want to address that one?
Yes.
Okay, great.
And so, like we kind of discussed before, we've seen that some courts have said the same thing that you're saying, that if the court is providing protection for, if the state is saying that you cannot discriminate against someone for having a medical marijuana card, that essentially means that you cannot discriminate against them for testing positive. Now, again, I pointed out in Maryland that we know that that's not the case because the Maryland Cannabis Commission, I believe that's the correct name, I could be wrong, but the state entity in Maryland that regulates it, they took time to put a line on their website to say that an employer can still fire someone for testing positive. So it's really important to keep up and to monitor what your state is saying you should do when an employee tests positive.
Great. And then the one regarding reasonable accommodation, what does state law say when it comes to providing reasonable accommodation to use it with regard to also the providing public services? So using transportation or living in public housing, that kind of thing.
Mm-hmm. So some of the laws that I went over, if the law says something like any right or privilege, then generally that's going to include everything. And a lot of these laws are very general. They're not just only on employment. Because this training was only on employment, I focused on the employment sector. But a lot of these states, if they're going to allow it in the employment area, you can kind of think that they're going to be on the same path for other public services. Now, housing, is sometimes federal or controlled by federal funds, so that's a little bit different. And you'll need to check your state and to see how they are handling it in that area. So hopefully you were able to see some of the states and how they write their laws, how some states do include any right, you cannot discriminate against this person at all. And so that would include those other areas unless they carve that out, or if that entity is receiving some type of federal grant that specifically says that they can't do it. And while we're talking about federal, I just see that there's a question about federal jobs, and I'm sorry I didn't say that, so I do want to address that. If you work for the federal government, medical marijuana is illegal. The end.
Wow, so that's straightforward, huh?
Yeah. And that's mainly because they're following federal law. The Controlled Substance Access is illegal. So you can't rely on your state law. If you're a federal employee, you're controlled by federal laws. And they went so far as to issue some sort of, I don't know if they refer to it as an executive order, but it was issued by OPM. But it just clarified that federal government employees cannot use medical marijuana because it is an illegal drug under federal law.
Gotcha. I think we had one come through via email. Hold on a second. Let me pull this up here. So it says, is there anywhere where under the influence is defined? Is there a clear definition for it? Because it can be vague and can be misinterpreted.
That's very true. And in most instances, under the influence is not defined. There was the one state that I addressed where they defined it as like 3 nanograms or something to that effect. But in general, there is no consistency on what it means to be high, like how, and tests aren't testing for that. So even if there's some research to say, oh, we think if you consume this much marijuana, then we deemed you to be high. Most drug tests, and when we're talking about drug tests in the employment sector, we're talking about urine tests. So they're not saying, like I said, they're not saying like, oh, this person is under the influence, or this person used the drug yesterday, or this person used the drug last week. They're just saying this person tested positive. And some of them may give like a number But again, there's not a whole lot of correlation to what that number means in most state laws. So it's very vague, which is why it's kind of important, if you can, which is why some people will just avoid dealing with the issue at all, with the obsession if the person is under the influence. Now, if a person comes to work, and a lot of us know what we call as reasonable suspicion testing, and you should have a policy on reasonable suspicion testing. You should have a policy that says, you know, this is what we do if we believe a person is under the influence, and this is how we determine if a person is under the influence. So for example, in the District of Columbia, we have this nice little sheet, and it has a whole bunch of check boxes. So it might say stumbling, slurred speech, bloodshot eyes. And you can find some of these forms on Google, but what you would do is have, it should be a manager, look at the person and say, you're exhibiting this, this, and this, and checking it off, and say, so we deem you to be, you know, under the influence, we're going to send you for a drug test. And if an employee has marijuana in their system and a reasonable suspicion testing, then that's a little bit different. And again, if they have like marijuana and heroin or something like that, maybe you don't know which one they're under the influence of, but at that point it doesn't matter. But if the person appears to be under the influence, you should have a policy that says you cannot show up to work under the influence, and that person has violated their policy, even if they're using medicinal marijuana. And that would be the same even if they're taking a legal prescription painkiller. They still cannot show up to work under the influence.
Gotcha. That's great. So another question here. What about a situation where an individual works in a state that does not allow medical cannabis use, but they live in a state that does?
Wow, that's a really good question. And I can see how there are some states where that can be possible. Of course, in the DC region, you wouldn't have to worry about that because DC, Maryland, Virginia, Pennsylvania, Delaware, they all have legalized medical marijuana, and that's generally where your employees would be coming from. If an employee is using a drug that is legal in their home state, I'm actually not quite sure how to handle that. I would say this though. The main thing is that they shouldn't be using the drug at work, especially if it is illegal in their state, right? Then they wouldn't be able to have it, but no one should be using the drug at work. But if it's legal in their home state, I really don't know how to handle that, because the person would be suing you in your state because that's, you know, that's where you're housed. And so I would think that your state laws would control, but at the same time, if they're doing something that's legal in their state, you're still allowed to have your policies that are consistent with your state. So if you have a policy that's consistent with your state law saying that you can't be under the influence or you can't use this drug, and you continue to test for marijuana, I mean, I would think that you were following your state law, but I don't know, that's a good question to look into. Let me say that.
Great. Let's see, next question here. Hold on just a second. Oh, there it is. So do the same rules apply across the board with regard to healthcare workers? Is there any difference for them?
So I think that would be controlled. I mean, healthcare workers have a lot of other regulations and licenses and things of that nature that they have to follow. So if there's something, for example, in your state licensing board that says that you can't have this drug, then of course that would trump whatever requirement. Now we see some of the laws have said when they put their anti-discrimination language in, they include professional licensing boards, meaning that a professional licensing board can't discriminate against a person for being a medical marijuana card holder, but that's really going to depend on the profession. Another good example is people that drive. Department of Transportation regulations generally have some control over that. So if there's some regulations or federal laws there that control what drivers can do, then those would trump whatever that state law is. If it's a federal law from the Department of Transportation or a regulation that says that drivers have to be tested for marijuana, for example, then you would need to adhere to that. And there are some rules, I don't know them specifically, but there are some special rules for drivers. So that's why some states like District of Columbia have exempted drivers from this pre-employment. They still require people who drive, people who are like firefighters, people that have these at-risk jobs or that may have some other regulations that control their profession. Those would not necessarily fall in the same category as other employees who are not subjected to those rules. So it would depend on the licensing entity and the rules regarding that particular profession. So your state should be able to, your state, for example, healthcare licensing authority should be able to provide some guidance on what their rules are as it relates to medical marijuana.
Right, and I guess if you go back to, anything defined as safety sensitive is probably a no-go. So, yeah. So back to, federal, more federal regulations. Are there restrictions, does it apply to organizations who just receive federal grants or, that prohibit illegal drug use?
So it's going to depend on the grants that you receive. I mean, you really want to look at where your funding comes from and the rules related to what you do and what obligations you have because you received that funding. And that's good to know in general because it could be something other than like a drug provision that you're required to do. So you should know those anyway because there are a lot of other requirements besides just how you handle drug testing. But like I said, the Drug-Free Workplace Act does not require you to test. So if that's the only federal provision you're relying on, then that's not going to be a protection for the employer. But if there's some other federal grant you receive, or if you sign some other contract with the federal government that says you must test your employees or you must adhere to the Controlled Substance Act, then those are going to control over your state law. That if there are no federal obligations on you, then you're not required, you can follow your state law. So you really need to look at where your funding comes from and what the requirements are for you receiving that funding.
Wow, right. So would it have any kind of impact on security clearance?
So yes, it could. If you're getting a security clearance from federal, you're going to be required to adhere to that. And that's the same as if you are a federal government employee. So again, you need to know what the requirements are and to determine whether or not it would impact you. So it would depend on if you're talking about some sort of state clearance, if your state does that. But if you're talking about a federal clearance, like some of them may test for drugs. And if you have marijuana in your system, then if you're dealing with the federal government for the clearance, that's going to be a no-go for them because under federal law, you cannot use medical marijuana.
Gotcha, that makes sense. We've got about 5 minutes left for any additional questions. Please put any questions you have in the chat box. One additional question here, I think this, it is more of an employee question. So if you're tested, and it seems like the question is if there's a pretty good chance you're going to test positive, should you disclose usage even if you used, say, a week ago?
So that's a very good question. If your state allows you to use medical marijuana and you want to disclose to your employer that you have used it, then there's nothing wrong with that. I mean, your state will, if your state protects you, then you're protected. It's kind of similar to the ADA setting in the sense of if you're telling your employer that you use medical marijuana, then you are pretty much putting them on notice that you have a disability, right? Because you have to have, in general, I'll just say in general, because you have to have some sort of ailment in order to get medical marijuana. It can't just be like, I have a headache. It needs to be like, I have migraines and this is impacting my ability to live my life. So that's just one thing to consider. I don't know that there's any state that requires an employee to disclose that. There may be some company policies on testing where it's helpful to disclose it, because the company may say, oh, okay, since you disclosed to us that you do use this, then we're not going to test you for this. Or we know that if your test comes back, we don't have to worry about getting into a conversation because you've let us know. So I would say, one, I mean, if you're not protected, it's not beneficial for you to disclose it, especially if it's illegal in your state. But if your state protects you, then the employer cannot fire you. But you're also not required to disclose it unless your company has some sort of policy or your state has some sort of law. And I'm not familiar with any state that has required disclosure. So I'll just say in general, it's probably not just required. And if you're an employer, you may want to think about whether or not you're requiring that, because you are actually requiring somebody to disclose that they have a disability if you're making them tell you that they have the card, especially if marijuana is legal recreationally and medically. You need to think about whether or not you need to ask that question in the same way you should think about whether or not you need to test for it. Like, what are you going to do with the information, and why do you need to know? Is there a business necessity? So I'll still wait for other questions, but I'll just move on to slide 67 real quick, just to tell you where you can get some more information. There's this really good article in the St. Louis University School of Law's journal. It's from 2019, but it's called Medical Marijuana and the ADA, Following the Path Blazed by State Courts to Extend Protection. And this is just a good one to see where the legal community, well, it's some people in the legal community are arguing that this marijuana field should go as it relates to employment. And it's written by Stephen Scandal. I'll also mention the National Conference of State Legislators. They keep a website on a variety of legislative issues, one of which is marijuana. And so they have a list of states that have legalized medicinal cannabis and states that have legalized recreational cannabis. They also keep a list of states that have anti-discrimination laws, and they keep a list of states that have laws requiring accommodation. And you can just click the link for your state and it'll take you straight to the information for your state. If you're curious about how an employee obtains medical marijuana, you can generally just go to your state's website and you can see the process. In general, an employee has to pay a fee to a licensed healthcare professional to obtain it. So it's generally not something you can just waltz in the store and say, I have migraines, what do you have for that? That's not how it works.
Anybody who is outside of the Mid-Atlantic region, there's actually a network of 10 regional ADA centers that provide guidance, training, and materials on the ADA. You can call the toll-free number from anywhere in the country at 1-800-949-4232, or send an email to adata.org and have your burning ADA questions answered. So, and I just want to thank you again for joining us. Thank you so much, Monica, for coming back and addressing this topic again. And again, we are the Mid-Atlantic ADA Center, and you can reach us by calling the toll-free number if you have questions, or you can reach us if you're in the Mid-Atlantic region at 301-217-0124, or you can email us your questions as well. Monica, you have any last words before we finish?
Yeah, I just want to say thank you all so much for having me. Thank you, Carlene and Maynard, for assisting with this training. I am just so thrilled to have all of you interested in this topic. I do see that there are some questions that we may have overlooked, so I'm going to stay and just drop the answers in the chat box for those that I missed. But thank you all so much for participating. You can find me on LinkedIn if you have any other questions, or you can email me at Monica, Monika, Dobbs, D as in dog, O-B as in boy, B as in boy, S at Yahoo, and I'll drop that in the chat box as well. But thank you so much for your interest. I'm looking forward to hearing what you guys have to say. Thank you.